Section 7, subclause 7, paying guest. A paying guest is specifically defined as a person who is given a part of premise in which licensor reside on a license basis. Paying guests are not protected under the standard eviction protection of Rent Control Act. Premises, section subclause 9, premises refers to a physical place being let or licensed. It includes any building or part of a building other than a farm building let separately. Appurtenance, garden, grounds, garages, and outhouses attached to the building. Fittings, any furniture or fitting provided by the landlord for use in that building. Section 7, subclause 4, legal representative. This term follows the definition found in the Code of Civil Procedure 1908. It means a person who in law represents the estate of deceased person. It includes any person who intermeddles with the estate of deceased, and in case of joint family property, the joint family of which deceased was a member. Relief against forfeiture is a powerful legal doctrine that prevents tenant from losing their leasehold rights due to a technicality or temporary default, most commonly non-payment of rent. In essence, it allows a second chance to a tenant to save their tenancy by making good on default before the court. In Maharashtra, this concept is primarily governed by Section 15 of Maharashtra Rent Control Act 1999 and Section 114 of the Transfer of Property Act 1882. Relief under Maharashtra Rent Control Act Section 15. The Act is highly protective of tenants and provides a specific statutory grace period to prevent eviction for non-payment of rent. The 90-day grace period, Section 15.15, subclause 2. A landlord cannot even file a suit for eviction based on unpaid rent until 19 days have passed after serving a formal written notice of demand to the tenant. Section 15, subclause 3, saving the tenancy. Even after the landlord files a suit, the tenant can stop the eviction, get relief against forfeiture if within 90 days of receiving court summons, they pay a full arrears of rent, pay interest at 15% annum, pay the legal cost of the suit as directed by the court. Ongoing compliance. To keep this relief, the tenant must continue to pay the standard rent regularly until the suit is finally decided. Crucial limitation. If a tenant had already been granted relief against forfeiture in a previous dispute, they may not be entitled to this protection a second time if they default again. The law doesn't favor habitual defaulters. Section 114, relief under Transfer of Property Act. For properties not covered by the Rent Control Act, like large companies with 1 crore plus capital or properties in non-urban areas, Section 114 applies. Discretion of the court, unlike Rent Act where relief is statutory right if conditions are met, under the Transfer Property Act, it is at the discretion of the court. Payment at hearing. If at hearing of the suit, the lessee pays or tenders the arrears, interest and cost to the lessor, the court may pass an order that the tenant shall hold the property as if the forfeiture have never occurred. General principle of forfeiture. A lease is forfeited under 3 main conditions: breach of express condition, violation of a specific must do or must not do clause, example, no subletting; denial of title, if tenant claims they are the owner or that the landlord isn't the owner; insolvency, if the lease agreement states the lease ends if the tenant becomes insolvent. The Maharashtra Rent Control Act 1999 ensures that while tenants are protected, landlords have specific legal pathways to recover their property. Section 16 through 22 outline these grounds ranging from tenant misconduct to the landlord's genuine need for the premises. Section 16, grounds for eviction. Section 16 is the matter list of reasons a landlord can ask the court for an eviction decree. These are broadly categorized into 2 types. A. Tenant's default or misconduct. Damage to property. The tenant has caused permanent damage or committed acts contrary to the Transfer of Property Act. Unauthorized structures. The tenant has built a permanent structure on the premises without written consent. Nuisance and illegal use. The tenant or their guest is a nuisance to neighbors or uses the property for illegal or immoral acts. Unlawful subletting. The tenant has sublet the property without a legal agreement. Non-user. The premises have not been used for their intended purpose for 6 consecutive months without a valid reason. Landlord's bona fide need. Personal occupation. The landlord reasonably and bona fide requires the premises for themselves or their family. Repairs and reconstruction. The property is needed for immediate repairs that cannot be done while occupied or for demolition to build a new structure. Recovery for repairs and re-entry. Section 17 and 18. If a landlord recovers possession specifically to carry out repairs, the work timeline, the landlord must complete the repairs and hand the property back to the tenant within a specified time. Section 18. Failure to occupy. If a landlord gets an eviction decree for personal use but fails to occupy the premises within 1 month, the court can order the landlord to put the original tenant back into possession. This prevents fake personal use claims. Demolition and new construction. Section 19, 20 and 21. These sections protect the tenant's right to a home even if the building is torn down. Section 19. If a landlord evicts for demolition but fails to start work within the time frame given to the code, they must return the vacant possession to the tenant. Section 20. Tenant's right to return. Before the new building is finished, the tenant can give notice to the landlord of their intention to occupy a tenement in the new building. Section 21. Once the new building is complete, the landlord must intimate the tenant. The tenant is entitled to the space in the new building that is roughly equivalent in carpet area their old one. Service tenancy. Section 22. This section covers cases where the house is a perk of the job. The rule: landlord lets a premises to an employee as a part of their employment. The tenancy is a service tenancy. Automatic recovery. Once the employee retires, resigns, or is terminated, the right to stay ends immediately. If they don't vacate, the right can recover possession without proving standard grounds listed in Section 16. The Maharashtra Rent Control Act 1999 outlines a strict set of rights and responsibilities for landlords. These provisions ensure that while landlord retain ownership and fair return, the tenant is protected from harassment and arbitrary deprivation of basic needs. Section 28. Right to inspection. A landlord has the legal right to enter the premises to inspect its condition. Requirement: the landlord must give prior notice to the tenant or licensee. Timing: the inspection must occur at a reasonable time. Purpose: generally used to check for structural damage, unauthorized alteration, or the need for repairs. Section 29. Essential supplies and services. Landlords are strictly prohibited from cutting off vital services to coerce a tenant. What included? Water, electricity, lights in passages, staircase, elevators, and sanitary conservancy services. The rule: no landlord shall, without just or sufficient cause, cut off or withhold these services. Penalty: the court can order immediate restoration. If the landlord fails to comply, they face a fine up to 100 rupees per day. Criminal liability includes imprisonment up to 3 months or fine of 1000 or both. Section 30. Conversion of use. The act aims to preserve the residential housing stock in urban areas. Prohibition: a landlord cannot use or permit to be used for a commercial purpose any premises which were used for a residential purpose on the date the act commenced, March 31, 2000. Penalty: conviction can lead to imprisonment for up to 6 months or a fine up to 10,000 or both. Section 26. Duty to give receipt. Transparency in financial transactions is mandatory duty. Mandatory receipt: every landlord must provide a written receipt for any amount received as rent, charges, or advance. Penalty: failure to provide a receipt can result in a fine of 100 rupees per day of default. Section 55. Registration of agreement in Maharashtra, the handshake deal is legally dead for rentals. Compulsory registration, even agreement for letting or live-on license must be in writing and registered under the Registration Act 1908. Landlord's burden, the responsibility for registration lies solely on the landlord. The tenant's advantage clause, if there is no register agreement, the tenant's version of the terms and conditions, including the rent amount, will be presumed true by the court unless the landlord can prove otherwise. Penalty, imprisonment up to 3 months or fine up to 5,000 or both. Lawful charges and increases. A landlord is entitled to a fair return but cannot charge pagdi or premium unless specifically allowed, like in the legalized pagdi system under Section 56. Standardized income, a landlord can increase rent up to 4% per annum. Improvement increase if landlord carries out structural improvement, they can increase rent by 15% per annum of the cost of such improvement. Tax pass through, if local taxes like property tax increase, the landlord can pass this increase on to the tenant. The Maharashtra Rent Control Act 1999 establishes a specialized judicial hierarchy, Section 33 to 38, to ensure that rent disputes are not mixed with general civil litigation. This exclusive jurisdiction prevents other courts from interfering in matters specifically governed by the Act. Section 33, Jurisdiction of Courts. The Act specifies which court has the power to hear a case based on the location of the property. In Brihan, Mumbai, the Court of Small Causes, Mumbai, has exclusive jurisdiction over all suit and proceeding between a landlord and a tenant relating to the recovery of rent or possession. In areas with small causes court, in cities like Pune or Nagpur, where small cause court is established under the Provincial Small Cause Court Act 1987, that court handles the matters. Elsewhere, in all other areas, the Court of Civil Judge, Junior Division, has jurisdiction. If there is no junior division judge, the civil judge hears the case. Section 34, appeals. If a party is unhappy with the decree or order of first court, they can move to higher tier. The appeal structure depends on where the case started. From Mumbai Small Cause Court, the appeal lies to bench of 2 judges of the Small Cause Court. Crucially, this bench cannot include judge who passed the original order. From other small causes civil court, the appeal lies to the district court of that district. Limitation period, any appeal must be filed within 30 days from the date of the order. What is not an appeal? When is an appeal not allowed? To prevent frivolous litigation, Section 34, Subclause 1 lists several no appeal zones. Small rent claims. No appeal lies if the suit is merely for the recovery of rents and the amount is less than 10,000 in Mumbai. Fixed standard rate, an order simply fixing the standard rent or permitted increases is generally not appealable unless it is a part of larger suit where an appeal is already allowed. Interim orders, orders regarding the restoration of essential supplies, are usually dealt with by the authority and do not follow the standard civil appeal route. Further recourse, revision and writ. No appeal, no second appeal. Section 34, subclause 3. The Act explicitly states that no further appeal shall lie against a decision made in an appeal. This means you cannot file a second appeal in the High Court on facts. Civil revision application under Section 115 of the CPC. A party can move the High Court for a revision if they can prove a jurisdictional error or a substantial question of law. With jurisdiction, parties often approach the High Court under Section 227, supervisory jurisdiction of the Constitution, to challenge a perverse or legally unsound order of the appellate bench or district court. Section 38, important procedural mandates. The Act sets ambitious targets for speedy justice. Suits should ideally be disposed on within 12 months of serving the summons. Appeal should ideally dispose of 6 months of service of notice of appeal. That was all for this video. See you in next video. Till then, like, share and subscribe. Thank you.